And we are back. Welcome to everybody that is online, and we are going to keep moving forward with Immigration and Citizenship Status Subcommittee, and I'm going to turn it over to Amy.
Thank you very much. Oh, sorry, I'll start again, and I'll repeat my joke.
It's not a joke, isn't it? The truth.
It's the truth, yeah. Thank you very much. I'm with the Subcommittee on Immigration and Citizenship Status. We are the last subcommittee, but we are second to none to our commitment to the Commission's mission. I want to thank the leadership of Secretary Becerra and Ambassador Tai, as well as our awesome federal team support staff. I'd like to introduce our co-chairs, Grace Huang and Kai-Ying Yang, and the other members of our committee are A.J. Butaria, Simon Pang, and Dr. Robert Underwood. Our ex-official member is Carol Wu, Senior Policy Advisor, Immigration Section, Office for Civil Rights and Civil Liberties, Department of Homeland Security, and our DFO is Sarah Edwards. I think we meet every 5 minutes. No. The Immigration and Citizenship Status Subcommittee actually meets bi-weekly only. Following the Commission's fourth quarterly meeting on February 5 and 6, the subcommittee met January 11th, January 25, February 8th, February 14th, Valentine's, February 22, and March 6. I'd like at this point to, I think we're doing our priorities. The priority issue areas for our subcommittee are strengthening asylum processes, universal legal representation for individuals facing removal, protection for undocumented individuals, improving language access for individuals at risk or facing immigration proceedings, including detained individuals, reducing the immigration court backlog, reducing immigration-based visa backlog, community-based alternatives to immigration detention, and visiting the impact of CARP, Controlled Application Review and Resolution Program on Immigrant Status. Our presenters include, over the last months, include Matt Adams, Legal Director of the Northwest Immigrant Rights Project. He presented on an overview of the U.S. Immigration and Services Controlled Application Review and Resolution Program, including the factors associated to make determinations and recommendations to improve the process. Also, we heard from the Bureau of Consulate Affairs, U.S. State Department. They presented on the processes of immigrant visas, including family-based, employment-based, and diversity issues. We also heard from Mary Cheng, Deputy Director, Executive Office for Immigration Review, U.S. Department of Justice, Lauren Alder Reed, Assistant Director, Executive Office for Immigration Review, also from the Department of Justice. They presented on language access in immigration courts, including how current policies and resources impact decision-making for limited English proficient or non-English speakers. I'd like to turn to Grace Huang to make our, to talk about our problem statement and recommendations.
Hi, thank you, Amy, and our first recommendation speaks to legal representation, but the problem that we are trying to address is the reality that despite the fact that there are really serious consequences to people being ordered removed from the United States in deportation proceedings, in particular on AAPI communities, that there are a significant number of individuals that go through the immigration court system without access to legal representation. So we know that so individuals of Chinese, Indian, Nepalese, Bangladeshi, Pakistani, Filipino, and Vietnamese descent were among the top 25 nationalities of individuals who were placed into removal proceedings between 2014 and 2018. The data shows that legal representation in immigration court can greatly reduce the likelihood of deportation. However, less than 50% of litigants in immigration court actually have counsel. Individuals that have legal representation are 5 times more likely to win their immigration, some kind of protection or relief from deportation. And individuals who are detained are 10.5 times more likely to win relief when they have representation by counsel. Let's see what else is part of the background. Folks that have legal representation appear for their immigration court hearings over 96% of the time, often because the attorney can help people navigate the system, letting folks know when hearings are, what the content and allegations are in immigration court hearings, and help folks navigate language barriers. And the statistics that I just cited are really unsurprising given how complex and conflicting immigration law can be. And also many people that are going through the process may have experienced recent trauma. They may lack financial resources, and they're unfamiliar with the U.S. legal system generally and specifically the immigration court system. And language access is always a barrier. So can we move to the next slide? So our first recommendation from the committee for this meeting is that we recommend that the commission recommends that the Department of Justice and Department of Homeland Security, DHS, expand access to legal representation for those in removal proceedings through the issuance of grants to nonprofit and other legal aid organizations with the purpose of providing universal legal representation by taking the following steps. First, the President's annual budget request to Congress that he just did, actually, for fiscal year 24 and for next year also, should include allocations to support programs to provide indigent legal representation for individuals in immigration court proceedings. And the administration should explore what funds are available within DHS, as well as Department of Justice and other agencies that could be used to support increasing indigent legal representation, such as, or in other words, appointed counsel in immigration proceedings in all jurisdictions, including at the Board of Immigration Appeals. So that's the recommendation.
Thank you, Grace. And thank you, Amy. Questions? Naheed?
I think this is a really important recommendation. I'm really excited to see all of the work that you all have done on this issue. It's a huge problem. Thank you so much. One quick question I had is, if the subcommittee discussed, there are so many proposals out there about this, and one of them is essentially creating a public defender system for the immigration court system. And I was wondering if you all discussed that in relation, like what made you make the decision to propose that nonprofits take this on and be funded rather than creating a system within government?
We didn't go to the extent of, we didn't go to the level of depth of whether it should be a entire system or not. I mean, my understanding of public defender systems in some places are that there are nonprofits that are funded. And so I think that it'll probably be I mean, I know this is, as you said, many are exploring this issue, and some of it would be dependent on legislation, and some of it would, I think it's contingent on legislation, appropriations, or funding, and I mean, the idea really is that there should be more resources for indigent legal representation, and at least start with the nonprofit structure, because there are such structures that exist and they could be expanded. Like right now, there are nonprofits that represent, unaccompanied kids, for example, or individuals that aren't competent to be able to participate in proceedings, and as well as in the context of certain populations like survivors of domestic and sexual violence or trafficking. There are those models already that exist, but expanding, I mean, I think this is a first step.
Other questions?
Just in response to that, I wonder, though, if there are risks in applying a model for the criminal legal system to this area of law. But I know it is about access and fully funding access. It would just be a question that I have. But I want to say to the committee that I'm so glad this recommendation came forward, and thank you so much for the work on this. And I think it could have huge implications and just save many, many lives. So I'm proud to have our commission be on the record.
I just had a couple of technical points on the first bullet point. Since the president's budget was just released last Thursday, is there any, I'm not, sure of the process, but is there any room for this fiscal year 2024 where they do negotiations and things to get some of this in? Maybe the staff can help explain that. And then also specify that for the fiscal year 2025, that it's in there in 2026 or what have you. So that's one thing. And then the second thing to Commissioner Qureshi's and Commissioner Pru's points, has the federal government convened any sort of summits on discussing the legal representation and the different models? And maybe that could be a next step where they bring a lot of different folks together to explore that. But thanks for this recommendation.
Grace?
I mean, I don't know about the first one. I mean, I would be amenable to allowing or amending or I would recommend amending the bullet point, since we wrote this before the budget came out, and amending it to include an annual allocation in the president's budget request. But with respect to your second question, I know that the access to justice, or what is it, that within DOJ, there's an initiative that Ana Paula that presented at our Language Access Committee. I know she's part of that Equal Justice Initiative, and I know one part of that ongoing working group is this question of access to counsel in civil legal proceedings for indigent individuals, including, I mean, immigration court is, immigration is a component of that, but I know that they're talking about it in the context of family law, all sorts of issues that impact low-income individuals. And I think the point of this recommendation was to highlight, in particular, immigration proceedings, because that sometimes gets forgotten when there's discussion of increased resources for civil legal services.
I was wondering, would it be appropriate to just say, support the president's annual budget in Congress for FY 2024, and also include allocations for future budgets, future years, to support programs. Since the budget has already been submitted, we would then support the president's annual budget request to Congress, and support and request and that this item should be included in future budget requests.
Can I ask a question? Is it in this year's budget already?
No,
Oh, I thought you just said that.
No, they said
No.
to allocate.
Oh, okay.
no. So I don't believe I haven't looked at that portion of the budget, but I don't believe there's an allocation for indigent legal representation. There might be for some of the limited, like, orientation programs, but not for actual representation. But we would want to include it for all future
Okay.
budgets.
I think the addition of "and future years" would be adequate.
I think we want to say FY 2025. Because 2024 is already out. Other questions?
Is there any, like, negotiating, like, when, I don't know what the process
I
is.
think once the budget is out, it's much harder to put it back, put something into the budget, so almost impossible to negotiate at this point, because it's all negotiating down. So, yeah, I mean, in the sense of like, it's going to come from somewhere else, because the budget picture is already clear, so it's going to come from somewhere else if they're going to negotiate now. So I think it's FY '25. Any other questions? Grace, do you have more? Okay.
I
Please, Victoria.
have a, excuse me, I have a question about, it says support programs. And so this is maybe, a question for clarification, because what does that look like? And, or is it like to provide the direct indigent legal representation through the courts, right? Or is it support programs? Because how I'm reading it, it's like nonprofits or other organizations. Is that what it was intended to?
Yeah, it was intended to, so right now, there are existing programs, whether they are, funded locally perhaps, or to provide, I know several communities across the country have such programs. And then in some places, your legal aid organization does this work. Like I believe in New York, for example, they've got a pretty robust Defender Association program. In some places, like the Victim Services Organization that may be doing this kind of work, or like there's programs that support children, that, for example, KIND does that kind of work in some places. So it just depends on, whether the project targets a particular population. We would like to expand it, of course, to as many organizations as possible that have that competency to be able to do the work.
Okay, this was great. Also very happy to see this recommendation, because it's such an important recommendation, and it matters so much to our communities, especially when you look at the statistics that you presented. Okay, we're going to move on to the next recommendation. I believe, Ajay, you are making the next recommendation?
Yes, thank you, Chief Commissioner Sonal. So this recommendation is about individuals who have been residing in the United States on H-1B visas. They face hardship and disruption as job loss results in the risk of losing their ability to remain in the United States if they are unable to find new employer sponsors within 60 days of being laid off. Burdensome H-1B visa restrictions and lengthy processes make it challenging for H-1B visa holders to complete the necessary processes within 60 days. H-1B visa holders face significant consequences when they are laid off from their job. After termination, they have 60-day grace period during which they must either leave the United States, seek a change of immigration status, or have another employer file an H-1B petition on their behalf. If they do not do so within 60 days, they are considered to be in violation of their immigration status. The H-1B visa holders' ability to maintain their immigration status becomes particularly important in the event of a layoff. H-1B workers are fortunate in that they have already been counted against the annual H-1B quota, making it easier for another employer to sponsor them. The H-1B worker is only considered to be maintaining valid H-1B status while working for their H-1B petitioner. However, a 2017 regulation from the USCIS gives H-1B visa holders a 60-day grace period after termination, during which they can find a new employer to sponsor their H-1B. There are several issues faced by H-1B workers that makes it difficult for them to find a new job and transfer H-1B within the current 60-day grace period. First, the job market is currently challenging, and it can take longer than 60 days for H-1B workers to find a new job. This is especially true for workers in specialized field who may have to go through multiple rounds of interviews and other selection process before being offered a position. In today's market, companies are taking 4 to 5 rounds of interviews, which may take several weeks before a candidate is offered a job. Second, even if an H-1B worker is able to find a new job within 60 days, the process of that transferring their H-1 can be time consuming and complex, and working with USCIS and completing a significant amount of paperwork and may not be done in timely fashion. Finally, if H-1B workers are unable to find a new job or transfer job within the 60-day grace period, they're required to leave the country. This can result loss of skilled workers and labor for the United States, as these workers may not be able to return unless they get a new H-1B in coming years. US tends to lose highly skilled resources, which are difficult to find within the country. Plus, these workers, there's kids may be ready to go to college, and etc. And if they have to leave the country now, they have to, their whole life gets jeopardized. So the Commission recommends that the Department of Homeland Security's U.S. Citizenship and Immigration Services, DHS USCIS, extend the grace period for H-1B workers from 60 days to 180 days to allow those who have lost their jobs to find a new sponsor without threatening their status or the status of their families. And this is in alignment with the USCIS based on our subcommittee discussions with USCIS. Thank you.
Thank you, Ajay. And just a note, for some of you in your packets, it may be, the order may have been different, so it may be 2 or 3, but we've sort of switched the order on the recommendations. Okay, Smita and Ijen after that.
Thank you. Thank you for the recommendation. I just wanted to comment that it's also a useful recommendation given the low unemployment rate and labor shortages right now. So having the access to some of the higher, having access to some of these employees might also be useful for the community at large.
Thank you. Ijen?
I was actually going to ask about the scope of directly impacted people and if some of the layoffs in the tech sector, for example, that have happened recently have affected this population of workers in particular. So are you seeing a increased need in the community right now for this? Because it seems like that would be the case, given all of what's happening in tech in particular.
Roughly what media reports around 200 to 250,000 tech layoff, 60% of which is folks on H-1B. That's what the media reports based on the different news agencies. And these numbers and these people are the hugely impacted people because of the 60-day rule. And I have personally received hundreds of messages on Twitter, LinkedIn, and others, Facebook media, of the issues these workers are facing. And I've been part of several boards, several social media groups where I've been hearing these stories. So does that answer your question?
Thank you, Ajay. Nahid?
Thank you so much for this recommendation, and I too have heard quite a bit about challenges in our different communities around these issues. I just wanted to make a quick note that I'm also looking forward to seeing our commission focus on the visa and other immigration needs for lower paid workers and those who are the most vulnerable due to lack of education, because I think this is absolutely affecting a diverse group of people but there's certainly a large portion of them, it's my understanding, and I'm happy to be corrected, that also are in somewhat better of a position than some of the folks in our community who are dreamers and in other positions that I also hope we'll be addressing as we move forward.
Thank you, Nahid, an important point. Teresita?
Thank you for that comments. Certainly for lower wage workers, this is not as much of an avenue because it's a premium cost for employers. In Washington State, agricultural workers are one of those that are in high need. And just as additional information for Commissioner Poon, this is a very important issue for healthcare. There's a lot of delay because of the needs for background checks and, checking their certifications, their academic credentials, so this would be helpful.
Yeah, I will say, for a lot of rural hospitals, this is a really important, especially with the lack of nursing, and the nursing shortages. It's, many of the rural hospitals are having to shut down wards for that. Yeah, exactly, exactly. Smita, you're, okay. And Nahid, anybody else have comments? Okay, let's keep moving. Ajay, I think you have the next recommendation too.
Thank you, Commissioner Sonal. Before I go into the problem statement for the next recommendation, I just want to share that very quick high-level process of a green card process. Companies hire H-1B workers and bring them to work, and then they file something called I-140, which is for to initiate. They go through labor certification and they file for I-140, which is initiating their green card process. And after many years, when their visa in their category becomes available, EB1, EB2, or EB3, these are the different categories. When visa status or green card becomes available, they file something called 485 and they get employment authorization card, which is called EAD, and which for many countries like India and China, where they have 7% country cap, it can take 50 years, 30 years, up to 100 years to wait time to get to that stage where they can get file 485 and get their EAD, employment authorization card. And what does employment authorization card does? It's like it allows you to work for any employer, and you can, with EAD and travel documents, you can travel in and out of the country easily. And it gives them, the workers, a lot of flexibility and dignity of work. So this recommendation, with that background, this recommendation says the backlog of employment-based visa, immigration green card visas places an undue burden on the individuals and their families who have approved I-140's immigration petition for alien workers. Some individuals have to wait more than a decade for a visa. This has implications for individuals because it stifles job opportunity and growth. It also negatively impacts the US economy by limiting the workforce and hindering economic growth. So before I get there, I just want to share that the families who are in this issue, they are facing separation in many cases. Individuals who are waiting for green card may be separated from their families, either because their family members are unable to obtain visas or because they are not able to travel to the United States while green card application is being processed. Limited job and travel opportunities. A lot of people, they do not go to their respective countries, even if their family members are, have their funerals or, in ICUs, etc. Lengthy processing time, uncertainty to settle down in life, and reported discrimination at workplace because they cannot leave their job, and limited career growth opportunities. So the recommendation is, the Commission recommends that, and we had internal discussion with USCIS, and based on their alignment with what we discussed, the Commission recommends that the Department of Homeland Security, USCIS, grant employment authorization documents, EADs, and travel documents to individuals who have approved I-140 employment visa petitions in the category EB1, EB2, EB3, who have been waiting in the visa backlog for 5 or more years, regardless of whether they have filed applications for adjustment of status. What this will do, this will allow um, uh, with the workers to have increased job opportunities, and they can access to a wider range of job opportunities, and ability to travel freely without worrying of visa stamping or visa appointments, and ability to connect with the family members and be able to continue with their lives, whether kids going to college or buying a home or settling down. Thank you.
Thank you, Ajay. Daniel?
Ajay, can you provide a little bit of context as to whether this backlog affects AA and NHPI communities more so than it does other immigrants? Just curious to see if this is a larger problem or focused on our communities.
This is a majority of people in the green card backlog comes from countries with AAPI related countries. There's a DHS immigration rule that only 7% of visa green cards can go per year each country. Some countries have largest number of workers who come on this visa programs from countries like India, China, etc. And because they have 7% cap, I think it's 220,000 or something. Only green card can be issued to countries like India or China or every country. Only the 7% cap. Because of that, anybody who has applied, who has come to US through countries like India or China or other countries, they have to wait like literally now 50 to 100 years before they can file for their 485 and get a green card number or green card, which means that they have been fighting going through legal through Congress. There was a bill called Eagle Act, which was asking to remove this 7% cap, but those are congressional bills which has to get approved to get around this. But this impacts hundreds and thousands of people living in the United States right now. And by doing this administrative process change will benefit all these people.
Did that answer your question? Okay, great. Other questions? Kevin?
Ajay, thank you for this. I'm still a little bit fuzzy about kind of how this all works, because part of the explanation and background talks about, so I-140, when you apply, are you still in your home country or are you here? Because when you talk about separation of families and restriction of travel.
Yeah, I-140, when you apply, you can be applying while you're working here in US. If you're an H-1B worker and you're working here in US, you can apply I-140, and that leads, that basically is on the, once you apply I-140, or you can apply I-140 when, if you're processing your green card application through your local embassy, and at that point in time, these applicants are not in US. But
How can you, sorry, how can you apply for a green card if you're not here? Like if you're in your home country, how can you?
Those are mostly family-based green card processes, which family-based, so if someone is sponsoring their family member, and they choose, there are two processes, and one is that you are in the United States and you go through the adjustment of status in the United States, or you can choose to get your adjustment of status done at an embassy in your home country. Those are two different processes.
Ajay, I can respond to Kevin.
Yes.
So the I-140 is filed by the employer, and it basically, they're like sponsoring an employee to say, this person's qualified, I have the need for a foreign worker to be able to.
Isn't that for H-1B though?
That's a non-immigrant visa that is limited in time and for a specific job, a specific purpose. And so the difference between the H and, or a non-immigrant visa versus a immigrant visa, allowing the person to come and reside indefinitely as a permanent resident. And so there are different requirements as it relates to, what the employer needs to show around the need for workers, et cetera. But often, as Ajay noted, like people do come on that non-immigrant visa. It's got a time limit, and they are, which can be extended, but the idea is if people want to immigrate and live here indefinitely, then, the employer can sponsor them through the I-140 process.
I'm only vaguely familiar with EB2, which is kind of you want to come and immigrate, but you have to invest in a business, right? So that's not really an employer.
That's
That's
EB5.
five.
No, EB5 is the $500,000 or now $1 million, but EB2, I thought EB2 is one where you can come and open up a business, and once you open up a business, you can apply for immigration. So anyway, my point being, over all of this, is that I'm a little bit uncomfortable with the language when you say, regardless of whether they file for applications of adjustment of status too, because, why would you, I don't know, create more of work for USCIS if you're not even sure that they want to apply for the adjustment of status, like take it for granted?
No, so there,
Go ahead.
I was going to say, the point is that they're not eligible to apply for adjustment of status yet because the wait is going to be 10 years down the line or 13 years down the line. So you're not eligible to apply for your adjustment of status if there's not a visa available. And so these folks are, here on a temporary visa perhaps, and then, it's kind of like this idea that you're just in the line waiting for the visa to become available. As soon as you're eligible to get your green card, you can. And the idea is you want to be able to get a work authorization before that visa becomes available.
This reminds me of what Secretary Becerra was talking about when we talk about REACH. I just feel like this recommendation is kind of addressing the entire immigration issue and overhaul that needs to happen. And we're like looking at one little piece of it and making a recommendation, which I don't know is so easily implementable. Yes, please go ahead.
Yeah, the statute, one of the reasons we made this recommendation is because the statute actually permits this in this narrow context, and the agency has not chosen to do that, and which it doesn't do in other contexts.
So the statute by law is saying that they can, anybody over 5 years, you can waive it regardless of?
No, the statute doesn't specifically say to do it. It's permissible, though, in this context. Go ahead.
May I add, Kevin? Kevin, there's no waiver here. What we are saying is that USCIS issues employment authorization card when you file for 485. 485 is filed when your visa current situation becomes current. So if, let's say, someone is applied for I-140 today, and they're in EB1 or EB2 or EB3 category, when today they are processing green cards for 2012 for India or something like that. So from 10 to 15 years from now, when they're in the line, when their slots open for them, they will be able to file for 485. At that point in time, they will be able to get EAD. What this recommendation in discussion with USCIS is saying, instead of issuing the EAD card 15 years from now, why can't we issue the EAD card when after the I-140 has been filed and they have waited for 5 years in the backlog already?
Isn't that because you said initially that there's a law that, or there's a I don't know if it's a law, executive order that caps it at 7%. So you're kind of trying to get around a statute that's capping at 7% by, which is why I'm saying it's such a bigger issue than just these type of applicants.
Yes. So the 7% cap is the number of green cards you can issue per year to each country applicants.
Right.
The 7% cap is not on EAD, employment authorization card. EAD is one step before the green card is issued. After you have EAD, then you wait for to complete the 485 process, and then they invite you for biometrics and et cetera, and then they issue a green card. But the number of green cards every year the USCIS can issue is capped to 7%, which is around, every country has the limit, and that's a separate thing. But there's no regulation or around EAD. And if you see, there's a reference in this recommendation, which is a memo which clearly outlines how and what USCIS can do to make this happen. And USCIS, when we went internally discussion, they agreed that if we could consider proposing with 5 years what we are proposing.
Louisa?
Yeah, I'm just trying to follow, because I'm getting a little bit confused. So the 7% cap is overall, right? That's it, right? And then each country has a different cap or
No,
falls within the
there's-
big 7%?
Within the 7%.
Oh, that's messed up, okay.
So what happens is that most of the tech workers come from API countries. A lot of the other comes from Brazil and as elsewhere as well. But largest number of chunk of them comes from countries like India, China, Philippines, Vietnam, etc. And because of the 7% cap, while applicants who applied from Brazil or Mexico, etc., their dates are current, which means that if you apply today for your green card, you can get in 6 months or 1 year. But if you are an applicant worker coming from India, China, or other countries, because there's such a 7% cap, which means there's a more number of applicants, let's say 1 million, and only 220,000 green cards can be issued per year for this country, then their wait times become much, much longer, 10, 15, or right now, based on the calculation, people from India can only expect in 100 years a green card. People from China is much longer, and so on.
Go ahead.
Yeah, I'm sorry, AJ, I'm just really trying to understand, because if I'm having a hard time understanding this, I don't, I just don't know how we.
Maybe Grace is there, she can explain it better.
Yeah, so,
Can we
So-
stick to, sorry, Lisa, I
Yeah.
think the problem is, Ajay's added in a lot more information than what is in
Yeah.
this particular recommendation. And I'd
Right.
like to stick to just this recommendation, which is about the EADs. And so did you
Okay.
want to add here?
No, I just wanted to specify, so for the 7% cap that Ajay is talking about, that's for employment-based green cards for everybody across the world, and there's a 7% per country cap. So larger countries like China and India, that have larger populations that are trying to immigrate on employment-based visas, oftentimes in high-skilled visas, tend to have a longer backlog. I feel like we're kind of talking past each other at this point, so it's a different issue, that per country cap and what he's talking about, and then this worker, and Grace, feel free to jump in. I'm not an immigration law expert, but I just feel like we're all kind of just talking past each other right now, so.
Exactly. So what we are not talking about is the 7% cap. What we are talking about is the EADs, and it's the step before you even get to a immigrant visa. And so this is just the ability to work while they're waiting, or to even before you even get put on the list. So it's just the ability to stay and work. So I just want to be clear, because there's been a lot of confusion in this conversation, but what we're talking about, and Grace, please feel free to clarify anything I say, but what we're really talking about here is just EADs. Go ahead, Naheed.
I thought I understood, and now I feel confused. I think the question I have is, so then are we just narrowly trying to address the problem of essentially China and India with this?
No.
We're not.
No.
No,
Okay.
it's for everybody.
It's anyone who has anyone who has
I'm
that.
sorry, I just thought that you just explained, or maybe Crystal
No, I
just
think you're saying
explained.
majority of the people tend to come from that, but it's not, it's for anyone, it would be for anyone that is in that category.
That exceeds,
Yeah.
but the people who exceed it are primarily those two countries?
Right
Right
now.
now. Okay, so then, in actuality, we are kind of proposing this essentially right now to address the problem with those two countries.
it's mostly Asian countries. It's not just China and India, it's Vietnam. It's also, it's
Okay.
everyone coming from any of the, it's largely the Asian communities are behind because of the caps. This is why the confusion is happening, but it's not specifically just addressing China and India.
But
Do
it
you
will
want to,
benefit every applicant, I mean,
Grace, do you want to,
from every part of the world.
Okay.
It will benefit everybody.
go ahead, Smita.
I was also going to say, so Sonal, it was very helpful, your comment, but so it's giving them the authorization to work, but also to travel, right? So that, I think that's also part of the thing that's causing a little bit of confusion, because I think the goal of this is to give them opportunities to work. I think the travel makes it seems like you're giving them essentially a visa.
There's something called travel documents, which is called advanced travel documents, which they are issued when they get EAD. And that's part of the process, where you can go back from there.
Can I just, I think, I want to just clarify. Let's just stick to, this particular is about an EAD. This is not about a green card. Let's just be clear about this. The travel piece of this is just that that visa allows you to move in and out and not be limited because of other limitations that exist. So I don't want to add too much more to this because this is a very limited authority that USCIS actually has. And it doesn't expand too much further than exactly what's written here. And I wouldn't add more to it because there's nothing more here other than just the EADs. Am I correct? Naheed?
I just would like to make a friendly suggestion that because there now is a bit of confusion about what this means and what the implications are, that maybe we take more time to look at the language, read, and understand this better before we vote on it.
I'm going to let the subcommittee move on this one. How are you all feeling? Do you feel like there's more explanation here, or do you think it's?
I think the confusion is that, okay, we're just talking about EADs.
Yes,
So are these people here in the United States, the I-140 applicants? They're not
Yes.
overseas, right?
they're in the United States.
Okay, they're already here. They applied for EB1, EB2, EB3. I looked it up. It's extraordinary ability professional workers, right? I was thinking of
Yes.
E1, E2, which is the investment one. But,
No.
okay, so EB is extraordinary workers, skilled workers. They're here in the United States. They're applying for the I-140. They get approved. And in the meanwhile, while they're waiting for their visa to become available, that visa allows them to do what?
Become a green card, get a green card.
Yes, that's an immigrant visa, so
Okay,
that
so
allows
in the
them to
meantime,
reside
they
in the
can't
United
travel,
States.
they just have to stick around in the US until that visa comes out.
Unless they've got a valid other visa that allows them to travel,
Right,
yes,
and
or
so
they
what
apply
we're
for a
just
travel document.
recommending is that now with this EAD authorization, while they're waiting for the visa, since they've already been approved
Correct.
for I-140, that they be allowed to travel. That,
Well, be allowed to work based on the work authorization versus the possible other visa they might be on, like a non-immigrant visa. So for example, if they are on a H-1B visa that ties them to a particular employer, that particular sponsor employer, and they get laid off, or they, I don't know why the employer would continue to sponsor their I-140, but that's another issue. But in terms of being able to get work authorization, even if that visa has expired, the non-immigrant visa, I'm sorry, I'm making it more complicated.
Like, this is the complication of the U.S. immigration system,
Yes.
right?
Yeah,
This is, I mean,
that's
this is
right.
like, this is absolutely the complication of the system itself. I just want, the president is speaking in Monterey Park right now. We can go to live stream. And what I might suggest is, let's just hold on this. We can close this discussion, but I want to just hold on this so we can go to the live stream. All right, to everybody that may still be online, we are going to do voting as quickly as possible before the president comes on in Monterey Park. So we're going to start with data disaggregation. Can we go ahead and put the data disaggregation I believe we had no changes to the Data Disaggregation Committee's recommendation. So,
Second.
all right, hang on. Luisa moves to approve, Smita seconds. Everybody in favor?
Aye.
We have a unanimous consent. Jay, are you good? Yep. Excellent. Language Access Subcommittee.
Is it up? 988?
This was the 988 recommendation. I believe, again, we did not have any changes to it. There was lots of really good conversation, but no specific changes. So
I move to approve.
Smita moves to approve.
Saijan.
Michelle seconds. Everybody in favor?
Aye.
Ajay, great. All right, we have unanimous consent on that. And remember, we have, for both of these, we have three commissioners that are not here. Rayno,
Raina.
Simon and Carrie.
And who?
Reynald is not on the line.
Who's the third one, though?
Simon and Carrie.
Carrie.
Yes. I just want to put it on the record. It's not more anything else, just to put it on the record. We're going to move forward with the Health Equity Subcommittee recommendations. We did have changes here. One was to take out the title, Tiger Youth Mental Health Campaign. We can work through a title, but we don't need that. The second piece was making sure we take into account other parts of our identity, including generational, multiracial, refugee, and adoptive. Does that, Mia, I think this was your recommendation? Great. Run ads with AA and NHPI celebrities discussing the importance of claiming cultural and community identity, however defined, which are protective factors against racism, homophobia, ableism, and other impacts on mental health. I believe this was sort of the breadth of the conversation that we had, and I think if everybody is okay with that, does anyone motion to approve?
I'll move to approve.
Luisa, Kamal. So I'm going to give, Luisa approves, Kamal seconds. Everybody vote, please.
Aye.
Aye. Ajay, yep. All right, we are all approved here, as, again, 3 commissioners not voting. Okay, do we want to keep going?
Yes.
I'm assuming the president is still not on. Okay, let's just keep moving. Belonging, inclusion, anti-Asian hate, sorry? Oh, sorry, did we not do all the 2? Sorry about that, my apologies. Establishment of national programs to raise awareness?
Yes.
Right, this is the one where we had monitoring instead of surveillance, data as well as nutritional options, including CMS as part of the list. And there was an addition on collaborating with federally qualified health centers, community, and patient stakeholders. I believe this meets our requirements of making sure that locally sourced information.
I move to approve.
Smita moves to approve. Mia seconds. Everybody vote, please. Aye. Ajay, good? Okay. Unanimous. Again, 3 commissioners missing. Third recommendation, this is collect language access data from federally funded community health centers. So there was a addition here, and the first part is excluding the utilization of family members as interpreters. This is just to make sure we collect the information appropriately, make sure we have the information. This is a baseline again that we want to start with. But what was also added here, which is HHS should permanently require the collection of language access data beyond the May 11th, 2023 expiration of COVID-19 public health emergency declaration. So this is already on the books. This is just saying rather than have it come off the books, that it would stay, it would become a permanent recommendation.
Move to approve.
This is already happening, just so you know. This is not anything new. This is just saying keep doing what you have been doing. Am I right, Teresita?
That's correct, but that's because of the COVID-19 public health emergency declaration. So HHS is actually collecting data from hospitals and all sorts of other providers. So Once that expires in May, this
won't do it
requirement
again.
goes away.
Yep.
Yeah, and so all
To
the
keep the
reporting
department.
processes will get dismantled, so we want them to keep doing it.
Great. Does anybody,
Move to approve.
Smita moves to approve? Who seconded? Sarah seconds? Everybody vote?
Aye.
Good. Okay. Unanimous. Again, 3 commissioners missing. All right, should we keep moving? Yeah. Let's keep moving. Belonging, inclusion, anti-Asian hate, anti-discrimination. We have, the first recommendation was establishing a permanent staff and agency to support WIAPI.
Second.
Again, it's just small changes here with language. And this is mostly to include in the, continue to include in the president's budget. So the budget gets included. Luisa moves, Smita seconds.
Aye.
Everybody vote? Aye. Okay. We are again unanimous consent. Let's keep moving. Recommendation 2, increase access to victim services. Again, slight changes to add culturally specific organizations and as well as disabled BIPOC organizations. Michelle moves to approve. Sorry, did you have a question?
No, it's disabled BIPOC organizations.
Okay, who seconded? Sorry. Victoria seconds. Vote, please. Aye. Okay, everybody, unanimous consent. Dr. Underwood, I'm assuming you're okay. All right, we're going to keep moving. Economic Equity Subcommittee had one recommendation on increased export opportunities for AA and NHPI small businesses. And this added XM Bank as well as language assistance. Teresita moves, Smita second. Aye. All right, everybody voting around here. It's going fast. Okay, we'll keep moving. Again, unanimous consent, Caroline. All right, we're going to go to Immigration and Citizenship Status Subcommittee. God, the moaning. Okay, we're going to go through the first 2, and then Grace is going to explain. Grace is going to explain the third one for more clarity. So let's go through the first 2, and then I'm going to hand it over to Grace to just give us more clarity and specificity. Okay. Recommendation 1, which is to expand access to legal representation for non-citizens in removal proceedings. And again, this was a very slight change to just recognize that the budget year had changed and added 2025 and beyond. So Amy moves, Teresita seconds. Everybody vote?
Aye.
Aye, okay. We are approved. Ajay voted aye. I saw his hand. Recommendation 2 is to address the visa backlog for, which one is this? Right, for certain employment-based immigration petitions.
No, that's the one that's been moved. It's the H-1B.
Sorry, H-1B1. All right, there we are. Extend to H-1B. Give visa grace period. There was no changes to this one.
Second.
Teresita, Smita seconds. Everybody vote, please. Aye. Huh? You say no. Okay, so we have Nahid saying no. So everybody yes, except 3 commissioners not here. Okay. All right, now Grace, I'm going to turn it over to you.
Okay, so I'm going to go and explain the employment-based process and what we're talking about here. So if people are immigrating through this process, it means there's an employer that has sponsored them and shown that this individual is qualified, to take a certain position, and they're qualified to immigrate and permanently reside in the U.S., get a green card in the U.S., based through this I-140 process. So the employer files that I-140. If it's approved, what happens is then there needs to be the second step where the individual themselves is applying for the green card. And so what happens is there's only a certain number of slots available for green cards from each country every year. And so what happens is for countries where there are high numbers of people immigrating through this process, there may be a very long wait. And as Ajay had indicated, some people are waiting 10, 15, 20, maybe, depending on the numbers of applicants in that I-140 process, they may be waiting decades. And so a lot of these folks are already in the United States. I mean, mostly they're already in the United States because they came years ago on a different type of visa, maybe as a student, maybe as a temporary worker, et cetera. So while they're waiting for that visa or the green card to become available, that immigrant status to become available, the proposal would just allow them to be able to apply to get work authorization so they continue to work lawfully. They've already been approved. The U.S. has already said, yes, we want you, you're fine, you can become a permanent resident. And there's just not a slot available yet. And so they are allowed to apply for a green card, a work authorization and a travel document to come and go, visit family, et cetera. That's all we're asking, that's all the proposal is, to try to alleviate some of that wait time that folks are facing.
You know, talk about how many people it affects?
Oh, and, okay, thank you. And we believe, based on the numbers from the State Department, that there are probably 200 to 300,000 people, in this particular position, the majority of whom are going to be folks from India and China, but it would impact anybody that would be in that visa wait for over 5 years.
Smita?
So I thank you for clarifying that. I would suggest, and it's helpful to sort of focus on this visa backlog for 5+ years. I would also recommend in this recommendation you strike the point after the word years, and regardless of whether they have filed application or adjustments of status, and just leave it as a period there, because if it's regardless, it doesn't matter anyway.
Good point. I think I agree.
Okay. Yeah, I think he's just, all right, so we're talking about striking that last sentence, great. Sarah?
Phrase.
Sorry, phrase.
Oh, I just had a clarifying question. So someone is sponsored by an employer, but they cannot work the whole time, this whole time while they're waiting? It depends on whether or not they have some other basis to be able to work, but generally, no. For example, if they were a student and their student status expired a while ago, or they, were here on a temporary visa, and that expired. I mean, a lot of these folks, because the wait is going to be a decade, 2 decades. I mean, likely their visa may have expired, and so they're just eligible for, they're a person here waiting for that green card. So,
who's sponsored by an employer?
yes.
And the employer accepts that they cannot work during that period?
Can I offer
So
Go ahead.
I want to add here that
Okay.
if I could answer the question, yes, they can work. President Obama in 2015, via an executive order, gave the DHS and USCIS.
Ajay, hang on. Don't add here because we just need to stick to this very narrow piece. So I'm going to ask
Okay.
Smita to just put in, just hold on.
Okay, so Sarah, based on my understanding of this, and you can clarify, I think I have the perfect case. I had an employee I hired 3 years ago. She was a woman who immigrated here from China. She was on her second master's degree, so she can maintain her EAD documents and continue to work with various employers. She actually ended up getting 3 master's degree until she finally got approval for her H-1B visa. And so she can maintain her EAD documents, and then now has her H-1B. But I think what happens is your H-1B also has a time limit. So while you're applying for these documents, you're just trying to get that EAD document that keeps you working and eligible to stay in the U.S. Is that correct? So this is my simple case study on this.
It's really just helping someone who has the documents to be able to stay and work. Okay. Are we clear? Kevin?
So, it's okay, you guys can, I'm just gonna abstain, because I don't feel, it's hard to grasp.
How many people feel confused and not able to vote? All right, I'm gonna propose that we just hold on this and get clarity and not move forward with this, because I feel like we've just now confused everybody. And I think we need just some facts and just some clarity as to what the actual number is and what we do. Ajay, I'm sorry to do this to you, but I think we're gonna have to just hold on this one. Please.
Since we're not going to be voting on this, I just have a question about how it impacts sort of that line that people are waiting on. Does this give them more priority if they get on it? It doesn't. So they would stay in the same exact position that they were in terms of the line for the green card. Yes?
Yes.
Okay, thank you.
Yes.
It is a very narrow provision that just allows them, it doesn't change, this is a great example of how confusing the immigration system is. And also, I think the earlier recommendations of having translation services, which is important, because if we can't understand just this piece of it, it can only imagine what a family is going through that does not speak the language, has to try to interpret.
Can I just, so
Sonal-
for Smita's,
Sonal, may I add
for
one
Smita,
last thing?
Hang on just a second, Ajay. Kimberly just has one comment.
for your case, Smita, yes, it's on. So she had to go to school to maintain her visa so she could work. So this EAD thing would make it so she didn't have to go to school, she could just work. Okay, got it.
So essentially, she was in the country, and I think when you have a student visa, you're also given the EAD. And I think that lasts for some period of time. So in order to not have to go to get continued education or having some ability to work, I think that's what the intention of this is. So it's actually an interesting one, because if she applied 5 years ago, instead of going for multiple degrees, which I find to be amazing, she's brilliant, but she could have eventually probably hit this EAD guideline, because after 4 years, yeah.
Ajay? Oh, actually, Ajay, go ahead.
All I wanted to say was that President Obama in 2015, via an executive order, gave the DHS and USCIS authority to issue EAD at a later stage. And this recommendation is requesting to advance that EAD issuance at when the I-140 and 5-year backlog is there. So we are just continuing with what President Obama's executive order was to issue this EAD. At a later stage, we are requesting to advance it, and USCIS is in alignment with it to do this.
Yeah, Ajay, I think the confusion is not in sort of wanting to do it. I think we just need to get some clarity, and the definitions around this needs to be just more clean. So I would recommend we just next time propose this, but just with a lot more clarity and a lot more narrowness. Ajay.
Can I make a comment that's not about this recommendation?
Okay, then let me close this conversation quickly. So just on this particular recommendation, asking that we hold till the next time so it can be more clear with just very clear definitions and maybe a couple of examples that help highlight what that looks like. Sorry? Yeah.
I was gonna say
Yeah,
that.
just
That would be
something that sort of simplifies and sort of shows that. Teresita?
Well, and my lay understanding is that previous presidential executive orders don't necessarily hold succeeding administrations. So if that can be clarified regarding this one, that would be helpful.
Absolutely. Thank you. Okay, we're closing this discussion on immigration. Okay, and EADs. I think that's it for all of our voting for this time. And so I'm going to move it over to iGen to change the topic.
I wanted to give the immigration committee some homework. Which is, I mean, I think the truth is that all of our committees are taking on topics and challenges that are way bigger than what is within the purview of what this commission can recommend, and sometimes what the federal government and its agencies can do. And I feel like that shows up so clearly in the immigration context, that what we can do within the confines of our mandate and what the federal agencies can do in terms of implementing our recommendation, it just feels very constrained. And I just wonder if the committee could spend some time thinking creatively about how we can actually have the right level of conversation about immigration and citizenship for our communities. Like, what should we be talking about? And what is the best way? I mean, these are challenges that is everything from, you know, the root causes of migration and the impacts of climate in the future to what do we do with millions of AAPI community members who are stuck in limbo without status, to the people who are on waiting lists, and how do we have the conversation we should be having about how to address this issue as a community? If you could just spend some time on that, because then I think it'll take the pressure off a little bit what we're trying to do with these recommendations, which are oftentimes very much in the weeds of policy, right?
I'm sorry, I just want to make note, because I don't know for the folks that are watching, right, that if they're in this status and in limbo, right, that I just want them to understand that, I guess as a commission, like we are, we care about these issues. I think that's why we are discussing it, right? We're trying to make sure it's thorough, that it's going to impact them the way that it needs, it's supportive for them. So I just want to make sure that we make note of that, right? That we're not just, you know, we're confused, yes, but we care about this topic. But I think to bring it up in the next round as a priority to clear it up, because it may be, you know, no criticism against anyone, but I think it's just maybe the presentation of maybe some of the terminology and then the knowledge that we may not have had, I guess for the rest of the commission that's not on the immigration, that maybe if it was presented in a different way. So I just want to make note, just for those who are watching that's in this status, right, that is needing that hope, right, is looking to us or looking for individuals who are in decision-making spaces, that, you know, I think we should definitely prioritize this and, you know, make sure that we bring this back up next time.
And I just want to, I want to sort of, you know, double click on both Aijen and Victoria's comments. I think from a perspective of, this is not to say no, this is just clarity so we know what we're voting on and what we're, that if everybody here is not clear on what we're voting on, then we leave with confusion and we vote on something that is not clear to each of us. So the purpose is not to table it. The purpose is to just make sure we're clear about what we're voting on. And to Aijen's point, and you know, as you think about all of our, at the end of our commission report, also to remind people why and for how it will affect all of our communities, as opposed to the details of the recommendations, which are very policy specific, but it doesn't mean anything to somebody if they can't understand why it matters and why it should matter. All right, so I believe we're moving on. The president is now on. We finished all the voting, so I just want to say thank you to all of you. Okay, I'm gonna go ahead and adjourn this meeting so we can stay and watch the president. We do not have to come back to this. So thank you to each of you. Thank you for participating. Thank you for the robust discussion, and we have a lot more to do, so thank you.
And just for official record, we officially adjourn this meeting. Thank you all.